All rise. Thank you. May be seated. Mr. Noble, you're still under oath?
Yes,
And
ma'am.
Mr. Bregman, you may proceed.
Your Honor, counsel, counsel, ladies and gentlemen. Mr. Noble, good afternoon.
Good afternoon.
I realize it was a long time ago, but did you tell this court earlier that you shot someone when you were a police officer and you don't know where you shot him?
I never saw the autopsy result. I know where I was at. I know probably where the bullets landed. Do I know exactly? No.
Okay, where did probably the bullets land, sir?
He had passed by me, so probably on his left side to his left back area.
Okay, his left back area. So if you don't remember specifically exactly where Mr. Ballantyne was shot, do you?
No, I never walked up to his body or walked up to him after he'd been shot, and I never saw the bullet wounds.
Would it refresh your recollection to see the Orange County Coroner's autopsy diagram showing the exact locations of all entrance and exit wounds of the person that you shot and killed?
Objection, Your Honor. I don't think you can refresh the recollection you never had in the first place. And this is not a document you've ever seen.
I just asked him a question. I think he can answer yes or no if it would help him refresh his memory.
Overruled.
Would it refresh my memory? No. I mean, I never saw his body. I don't know exactly. I mean, I assume, but I don't know.
So you shot and killed somebody as a police officer, and it never even occurred to you that you might want to know where you actually shot him?
I had been a police officer for 6 months at the time this happened. It was 31 years ago. I never went back and got a copy of the report. I didn't know I was even able to do that at that time.
Well, you do now, don't you? It's been 30 years, right?
I do now.
You hold yourself out as an expert in police procedures and practices, and you've never been curious to even know where you shot the guy that you killed?
Quite frankly, it's not an event in my life that I want to relive, and I've talked about it more here today than I've talked about it in 30 years.
So when you pulled the trigger on the man and shot him, did you see where the bullet went?
Did I see where the bullet went?
Yes.
No, I don't remember that.
Do you remember where you were pointing the gun at him?
Yes, I was pointing at center mass.
Center mass, was that his back?
From the angle he was at, it was his left side.
So just to be clear though, where someone's bullet wound is has no bearing, none whatsoever, on whether or not the shooting is justified, correct?
That's absolutely true.
Okay, did I spell your name right?
You did.
N-O-B-L-E? Okay. So bullet entrance location has no bearing on justification. You'd agree with that, right?
Well, it depends on the circumstances. I mean, you look at the totality of the circumstances. So if we have witnesses that the person's back was to him, he was in a give-up position, he got shot in the back with the bullets, offer some evidence, of course. So does it necessarily? No.
The first time I asked you that, you agreed with me, right? Do you still agree with me or not? You want to change your mind?
I think with again, the reasonableness and the totality of every situation is different.
So now you don't agree with it. The bullet entrance location has no bearing on justification. Now you believe that the bullet entrance does have a bearing on the justification of the shooting.
It could.
So you've changed your mind now within a span of 30 seconds. Is that correct?
Objection, argumentative, and badgering, Your Honor.
Sustained.
Perhaps it was my tone that was a little too loud, Your Honor. Would you agree with me that you've changed your answer to the same question within a minute's time?
I believe I've clarified my answer.
So was it a definite answer the first time that you gave me?
Sir, I believe I've clarified my answer.
I see. Now, when you look at these type of cases, when you come in and act as an expert in a officer-involved shooting, you want to know and understand the totality of the circumstances that surround us, right?
Yes.
You want to know everything that the officers knew, right?
I want to know the relevant facts, yes.
But you want to know everything. It's just like you want to know just as much as someone who might be conducting a homicide investigation, right?
It depends on the case, and it just depends.
Well, sir, you'd agree with me that before you come in here and say that these two men are murderers, you would want to be able to have an understanding of what all the evidence is, right?
No, I want to have an understanding of what the relevant evidence is.
So you would agree with me that you purposely did not read any of the interviews that the investigating officer did of the police officers at the scene, correct?
That's not correct.
You read Officer Sandy's?
Yes.
You read Officer Perez's?
The interviews at the scene?
Yes.
No, there were no interviews at the scene.
Were there later interviews conducted, sir?
Yes.
From officers that were at the scene?
You said at the, you're speaking so fast and you're talking in a manner.
I get that way. I'll
You
slow
do,
down.
so slow down, thank you.
You bet. So tell me something. Did you read any of the interviews that Detective Stone conducted in this case, other than those two?
I'd have to go back and look at the totality of the report. I believe they were all contained in the report.
So you've come in here now to court and you don't even know. You don't even know if you've read all of the interviews of the officers that were out there, do you?
I certainly read the summaries of those interviews that were contained in the report, and if there were interviews that were transcribed and contained in the report, then I read those as well.
Well, how can you be confident that you have a complete understanding of the totality of the circumstances in an officer-involved shooting if you freely sit there and admit that you haven't even reviewed all of the evidence that was gathered?
Because it's not necessary. What's important or what the relevant evidence is what I reviewed.
And see, in fact, you know that some evidence you just don't need to look at regardless of what may be contained within that interview, right? You just have that ability to say, you know what, that officer, I don't need to hear what he had to say. Is that right?
No, again, there's a investigative report where there's summaries of all the interviews contained in it, and I read the entire investigative report.
I see. But you decided to pick and choose which ones you're going to educate yourselves about, right?
No, if they're contained within that report, I didn't make a list of them. If they're contained in the report, I read.
Okay, I see, sir. And so, by the way, the information that you got was only the information that this prosecutor sent you, right?
Yes.
So if she didn't send it to you, you don't know about it, right?
If there's something else out there that I didn't receive and I'm not aware of it, then I don't know about it.
You understand that there was a case agent involved in this case that actually did an extensive amount of work, right?
It wrote an investigative report, yes.
An investigative report. He did a tremendous amount of work on this case. You can tell just by reading that report, right?
He conducted an investigation, yes.
And that gentleman's name was Detective Stone, right?
Yes.
And he's a homicide detective, right?
Yes.
Did you call him up and ask him any questions?
No.
You don't care what he has to say?
I relied on his report.
You relied on his report, but you didn't have one question after reading his report?
I think I had a lot of questions after reading his report, but I wasn't asked to conduct an evaluation of his investigation or his report.
No, but he was the one that collected all the evidence and, at least as far as this investigation is concerned, had the most information about it, didn't he?
And he wrote a report.
But you didn't take the time, you didn't think it was necessary to call him up and ask him what his thoughts were even about this case, did you?
Yeah, I've never done that as an expert witness. I've never spoken to a witness.
Let's talk about how many times you've been actually recognized in a court of law as an expert. Today was the third time?
For what type of case?
You actually recognized in a criminal case as an expert in court. Is this the third time?
For a use of force, yes. For
Okay.
other kinds of cases, no.
And the other time, there was two other times I think you said in federal court, right?
2 other times in federal court, yes.
And neither one of those times was the defendant a police officer?
One time the defendant was a police officer, one was for the plaintiff and one was for the defense.
Okay, one was for the state, is that what you're saying?
No,
criminal case?
they were civil cases.
Oh, I know. I want to know how many times you've been recognized as an expert. I'm sorry, bad question then. I want to know how many times you've been recognized as an expert in a criminal case, sir.
This is the first time I've testified as a use of force expert in a criminal case.
And okay. So you're not applying civil liability theories to this case, are you, sir? You're not looking at this through the lens of civil liability, or are you?
No.
Do you know the difference?
Yes,
You're a lawyer, right?
yes,
And are you a lawyer for sure today? I mean, yesterday we were back and forth a little bit on that. You agree with me that you are an absolute licensed lawyer,
We
right?
actually moved to strike the argumentative part of that question, Your Honor.
Sustained.
I'll withdraw it. Thank you, Your Honor. So, do you believe, I think you said that police officers are required to follow the procedural orders because the orders and they are just required to do that, right? The procedural orders?
yes,
Okay. And they can't pick and choose which ones they want to follow, can they?
no,
They have to follow all of them, right?
yes.
And why is that?
Police departments put orders in place in order to control the behaviors and actions of their officers to prevent misconduct.
And you agree with all of the procedural orders of the Albuquerque Police Department, right?
Oh, I have no idea.
Well, have you reviewed all the orders that these officers were required to follow on that day in question, March 16th, 2014, or not?
No, of course not.
Of course not.
Of course not. The policy manuals are hundreds of pages long that would have many policies that would have nothing to do with the use of force situation.
Well, it would have taken a lot of time to read all that, right?
That's not relevant, but yes, it would
Well,
take a
isn't
lot
that
of
what you
time.
just talked about when you said how thick the pages were, how many different pages there were? Isn't that why you're saying that? Because there's so many of them, it would have been tough?
No, it wouldn't be tough.
Okay.
I read a lot of documents all the time.
Okay. Do you get paid by the state for this case based on the number of pages you read, the hours you spend, or on the product, or what you say when you sit there? What do you get paid based on?
I get paid bit for my time.
You get paid for your time?
Yes.
So when you only look at some of it, are you at some of the case, for example, not everything, not all the report, not all the transcripts perhaps, not every video you said you haven't reviewed, and you certainly have just said you didn't look at all the procedural orders that these officers were required to follow, then would it be fair to say that you were giving the state a discount because you weren't charging them as much by the hour then? Or as many hours, right?
No, I charge the state for my time based on the material that I reviewed.
So tell me something, how much have you actually charged the state of New Mexico for the work that you have done up to date, including through the rest of today? I'm sure we'll go to 5 o'clock. Tell me how much money you've actually charged the taxpayers in New Mexico for this.
I've billed $7,600 for my preparation of the case, and then I'll be charging for my travel time and for my testimony yesterday and today.
Okay, so would you agree with me that if you weren't paid, you wouldn't come here and say what you said?
No, this is a job. Yes, I'm working. I'm being paid for it. I'm being compensated for my
No,
time.
yes, that you wouldn't come here and testify unless you were being paid.
No, I wouldn't come here to testify if I wasn't being paid.
I'm sorry?
No,
You would not?
no.
Just give me a second. So let me give you one more chance so we don't write it and then change your mind. So would you agree with me that you would not be here unless you were paid?
I agree.
How much were you charged for today?
$2,900.
$2,900? Now, who paid for your airfare out and back?
The state.
So let's get back to the procedural orders. And I think you've already said that you didn't have the ability because they were too voluminous to read all of them. Is that right?
It's not a matter that I didn't have the ability. I mean, when we're talking about procedural orders, there are orders in a policy manual that cover everything from how you wear your uniform, what uniform's appropriate. There are all sorts of orders.
Okay. But you absolutely say today, under oath, that you believe that these two officers have to follow every word of those procedural orders, right?
I believe that when a police department puts all orders and policies in place, and there's an expectation by the department that they follow them, yes, they're going to be following them.
Okay, so do you agree? Is there any procedural order that we've talked about that you don't agree with? Today, the last 2 days, is there any procedural order that you say they shouldn't have to follow?
No, I don't think there's anything they shouldn't have to follow. I mean, are there procedural orders that I would write differently, or if I'm making recommendations? Yes, but is there a procedural order they shouldn't have to follow? No.
Can we turn the Elmo on, Your Honor? I don't know how to. Thank you. Now, this is part of Exhibit 1, is what I'm going to be showing you. It's page 2. And do you see up there it says objective reasonableness?
Yes.
We've gone through that, haven't we, already a little bit, but I just kind of want to understand something. You don't agree with this order, do you? You don't agree with it?
Well, I think the only thing that I would disagree is the word "the," where it says "the reasonable officer on scene." It should be "an," A-N, reasonable officer on scene.
So you don't like the word "the"?
No, because it implies that the test for reasonableness should be decided by the officer who actually used force, and that's not right.
How about this? Just based on your testimony, how do you like this part right there?
Well, I think that you know, in the way that the policy and the law is written, that's part of the Graham decision, and we've discussed that thoroughly.
And so right here, the words before it, where it says rather than with, you don't like those words either, right?
No, I don't have any problem with it because that's consistent with Graham.
I see. It's consistent with Graham, but earlier you had a lot of conversations about, of course we do hindsight, and hindsight does matter. It's just, it's hyper, what was the word you used? Hyper what?
Technical.
Okay, where is hyper-technical in the procedural order?
Again, it's not going to be in there at all.
Okay, where is the word hyper-technical in Graham versus Connor, the United States Supreme Court opinion?
It's not in Graham.
Okay, that's something you came up with?
No, it's not something I came up with.
Okay, all right, so would you agree with me that the order and the case that it's basically referring to, which is Graham versus Connor, says nothing about hyper-technical. It says basically you're supposed to judge it from a reasonable officer on the scene at the time rather than with 20/20 hindsight. Isn't that what this says?
That's what it says.
And you're doing it with 20/20 hindsight, right?
Of course.
So if you were a cop back at Irvine, and this was your order, I guess you'd be violating procedural orders. What kind of discipline do you think you should receive if you were doing that for violating a procedural order?
Again, I wouldn't receive any discipline, nor would I expect anybody to receive any discipline.
So it's okay then, if you're the one choosing which orders not to agree with or to violate, then somebody shouldn't get any discipline for that. That's what the way they do it in Irvine.
No, sir.
Okay. So do you have a problem with the fact that the Supreme Court said and directed, the Supreme Court of the United States directed all of us to judge police with based on the reasonable officer on the scene at the time of the action rather than with 20/20 hindsight? Do you have a problem with the Supreme Court?
I don't have a problem with the Supreme Court.
But if you're a lawyer, you recognize that lawyers should follow Supreme Court rules, right?
I also recognize that Supreme Court rules get further interpreted by subsequent cases.
Okay, but you don't want police officers to start interpreting this order, do you?
I want police officers to be trained. We have policies, and then we supplement those policies with training.
Do you believe a police officer should be able to rely on a statement like that right there? Should they be able to rely on that if that's the procedural order?
I think any police officer that looked at that and said, you know, gosh, I can use force and nobody can look at it with hindsight, therefore I can never be evaluated, therefore the department can never hold me accountable for any type of use of force, that I'd never be held criminally or civilly accountable, I think that would be an unreasonable police officer.
But that's not what this says, is it?
I think, again, you have to interpret it through your training.
So, right, that's not what this says. This says the perspective of a reasonable officer on the scene at the time, right?
That's what it says.
Let's talk about how you are interpreting the events of March 16, 2014. You're interpreting them predominantly based on a video, is that right?
No, I'm looking at the totality. The statements of the officers are certainly important. The video is important. For the immediacy of the threat, I think the two key factors are the statements of the officers and the video.
The video. The video is one of the key factors for you when it comes to the immediacy of the threat, correct?
One of them, yes.
Now, let's talk about how far away was the video shot from Mr. Boyd? How far away was Officer Perez's helmet cam from Mr. Boyd?
As I recall, he's about 21 feet.
Okay. Would shock you to know that it's 25 feet, sir?
No.
Okay. Would you agree with me that it's 25 feet?
No, I would neither agree nor disagree.
Okay, what would you base the 21 feet on? Did you go out and measure at the scene?
No, there's no way for me to measure at the scene. I mean, Mr. Boyd's no longer there. Mr. Boyd wasn't there. Officers would have to point out where Mr. Boyd was at.
Actually, there's no way for you to measure at the scene because you've never been to the scene, have you?
Nope.
don't you think it would have been good before you come into court and call these two officers murderers to at least go out and take a look around at what happened?
Objection, Your Honor. I'm going to move to strike, again, the argumentative nature, the thing he keeps adding, calling these two officers murderers. That's the thing he keeps adding to his questions. I'm going to strike that as argumentative and obnoxious.
Obnoxious.
Well, I don't know of that rule of evidence, but as far as argumentative, I'll sustain that objection.
Okay. So let me rephrase so that it's perhaps not as argumentative. Don't you think before you come in and give an expert opinion in which you could pay thousands and thousands of dollars, that it would have been beneficial to at least everybody here in the courtroom to have an expert witness that actually had been to the scene where this has happened?
No.
So would that be good police work, in other words, to try and figure out what happened someplace, not even to go out there?
No, of course not. It would certainly be better if I believed that I could get the officers to go out there and talk to me and demonstrate the scene to me. That would have been wonderful. That wasn't going to happen.
You didn't call up Detective Stone, who was the case agent, who did all the investigation out there, ask him to take you out there, show you where everything took place, because you would agree with me, you read his report, he knows where everything took place, doesn't he?
He conducted an investigation, yes.
So he does, right?
He should.
So maybe, I think you could probably talk to Detective Stone. Did you try?
No.
Okay, wouldn't it be better for you as an expert witness to have at least been out at the scene?
No.
All right, so it's 25 feet away, or you say 21. Do you know?
I don't know. I thought it was 21. I'd have to go back and look at the report.
But I mean, if you're basing your decision on one of the two basic things about the immediacy of the threat is based on what you see in a video, wouldn't you want to know how far the video was away from what was being taken place?
I think I have a pretty good idea. It's about 21 feet.
And what do you base that on, sir? Where's 21 feet anywhere?
I'd have to go look in the report. You're saying it's 25. I think that's pretty close. I mean, I don't know. I'd have to go back and look.
Well, feet make a difference, doesn't it, in this kind of a case?
It may.
Well, let's do this. Can I approach the witness, Your Honor? Take this, and I'm going to tell you when I get to 9 feet. Let's see. This is 9 feet right here, right?
I don't know. I can't see that into the tape
Here,
measure.
I'm going to stop it right there so you can see now, okay? You see that? Is that 9 feet?
Shows in inches. I can't do the
Yes.
math. Does it indicate?
What is that right there?
All right, 9 feet.
Okay, 9 feet. You can look up. I'm sitting right here, standing right here. This is 9 feet. It's really important when analyzing this case how close Mr. Boyd is to the police officers, isn't it?
Yes.
So wouldn't it be real important to know how close the view you're getting to watch what happened? Feet make a difference, don't they?
They can.
Okay. So somewhere between 21 and, I said 25, but you say somewhere in between there, right?
I don't think there's much of a difference between 21 and 25 when it comes to that, the video.
You don't?
I don't.
Okay. And so how far away is Mr. Boyd when he shot from the dog handler and Mr. Sandy?
How far?
How far away are they?
9 feet.
9 feet. Okay? Now, if this is 9 feet right here, and we talked about that, right?
Yes.
So let's double that and add it and almost triple it. This is how far away that camera was about, right?
Okay.
Is that right?
If that's about
Would that be
right.
fair?
Seems to be.
Guesstimate?
It's not a guesstimate, but an estimate, yes.
Oh, it's an estimate? Here, somewhere around this area, right?
Sure.
So, when we're talking about the actions of someone who's sitting where you're sitting, wouldn't you have a better understanding of what you, for example, are doing in that chair if you're right here than as opposed to right here?
Sure.
So when we talk about this thing on the elbow, it says, perspective of the reasonable officer on the scene. Do you see that?
That's for making the use of force decision, yes.
Right. Keith Sandy has a better perspective of what Mr. Boyd is doing 9 feet away, doesn't he, than you do watching a video over here, right?
It depends. It depends on whether or not what Mr. Sandy's perceptions were and his ability to perceive.
So you don't know anything about what his abilities to perceive were at the time?
Of course not. I mean,
Okay. So would you agree with me, normally though, someone that much closer would have a much better ability to perceive than someone this far back, right?
I would agree they have a much better opportunity.
Much better opportunity. Oh, there's another big difference, isn't there, between what Mr. Sandy saw on that day standing right here and what you see in the calmness of your office and out in the courtroom from back here. What else is the big difference between the two of us, sir?
I don't know what you're referring to.
Well, let me try this. When it's film, is that 2D?
Yes.
Okay, Mr. Sandy, when he's looking at Mr. Boyd on March 16, 2014, he's seeing in 3D, isn't he?
Yes.
Isn't 3D a better opportunity to see people's movements, especially if it's towards someone, than 2D?
Yes.
So concede with me this, if you will. Mr. Sandy was in a better position at that day, being there, to perceive the actions of Mr. Boyd than you are back here watching the video from 25 feet away.
He may have had a better opportunity, yes.
Now, you don't know what Mr. Sandy perceived, do you?
Well, we know what he said.
Right, you don't know what he perceived, do you?
We know what he said.
Is that a yes or a no to my question, sir?
Well, sir, what it is
Here's the question again. Let me ask it again.
No, you're cutting me
Let me
off.
ask it again.
Wait,
It's a
one
yes or no
second,
question.
1 second. Let me just explain. I know that you both know this rule, but I'll highlight it anyway. One person speaks at a time. So we'll start with a question. The question will be completed, and then the witness will answer the question that is asked.
Sir, you don't know what Mr. Sandy perceived, do you?
No.
I'd like to show you the video. And I want to ask you just a couple of questions based on what you said during your direct testimony, okay? I think we're going to need to switch.
HDMI on it?
It's not up. I don't know. We're not doing something. Oh, maybe. There we go. So I want you to do one thing and one thing only for me, okay? Mr. Noble? I want you to
Yes.
do one thing and one thing only. I just want you to watch Mr. Boyd. Just don't watch anything else. Just watch Mr. Boyd. And tell me what he does. Right there. Okay, let's back that up. Now, what is he doing right there and then? Now, one more time, just watch Mr. Boyd. Does he take a step right there, sir?
No, I don't believe he does.
So what's he doing? Why are
What-
things
what-
in the
can you play it
background
again? I'm
moving?
sorry.
Why are things in the background moving as opposed to him then? If that's not a step, sir. You're not going to concede.
I don't see a step forward toward the officers there, no.
You don't see a step towards the officers?
I see some motion. I can't tell whether or not he's making a step. I don't see it.
Well, let's let you look one more time. You see that now, sir?
Yes.
Does he move his foot?
I can't tell.
So, you agree that you have to arrest a felon, right?
Yes.
They had to arrest him that day, right?
Yes.
They can't wait till it gets dark, can they?
Of course they can.
You think they could, you want him loose on his own in the dark now where they can't see him as well?
What do you mean loose? He was surrounded by 19 police officers. Police officers work at night every day of the year. They're very capable of working at night.
Really, he's in a rugged area of the foothills. You've never been to the foothills, have you?
Not here in Albuquerque, no.
Do you know what's even on the other side? Do you even know what's, you saw the picture in opening I showed of the neighborhood, right?
Yes.
Okay, what's the other direction? Do you know what's going the other direction?
I have no idea.
But yet, you're willing to sit here as a sworn expert and tell this court that you think he could just leave him there in the dark, not knowing what's out there.
Nobody's just leaving him there in the dark. There were 19 police officers at the scene.
What type of lighting did they have to keep an eye on him?
Police officers are generally equipped with flashlights. The SWAT team was arriving. There's additional equipment.
Sir, does darkness play a role in the decision-making process of when to arrest a man?
It could.
It did in this instance, didn't it?
There were some discussions about darkness, but those discussions were never communicated.
Communicated to who, sir?
There was no discussions. Nobody talked to Sergeant Fox about this plan. Nobody talked to other officers about this plan. This was an ad hoc plan based on 3 officers that was reckless.
You haven't even listened to all the dispatch tapes, have you?
No, I'm sure I haven't.
How can you say that then? How can you sit there like that and tell this court that nobody discussed it, nobody communicated darkness when you haven't even listened to it, sir?
Objection, argument in your honor.
That's not argument.
I'm going to allow that question.
No, there was discussions about darkness, but there was no discussions about whether or not that darkness should do that, and that whether that played a role in this ad hoc plan. That plan should have been communicated, as we've discussed.
He also said that he can live, die, kill in the dark, right?
He did.
So, you know, another part of that exhibit that we used, if we could switch back to the Elmo, Your Honor, thank you. Another part of that exhibit that we used, page 5 of Exhibit 1. You see that?
No?
I'm sorry, you can't see through it?
I do now. It took a second for the monitor to
pick
come
up?
on. Yes.
You see that now? Look at F. And there's actually a part underlined here. You see that?
Yes.
One's control of a combative subject is gained. You went in and talked to, I don't know, you've talked about this particular policy 4 or 5 times already and just defining what the officer's duties are. I'm sorry, but wouldn't you agree with me that Mr. Boyd was not controlled?
Yeah, I agree with that.
Then this doesn't have any bearing on this case, does it?
I think it was brought up in the discussion of simply that. Is if somebody's in control, that force is no longer reasonable.
So, right, but that doesn't have any bearing on the issues in this case, does it?
No.
Do you have any understanding of why the prosecution even brought it up then?
No.
One thing I wanted to make sure that we got out was, I'll find it. There it is. One thing I wanted to figure out, or make sure I memorialized on this little notes I'm taking is that Boyd never surrendered, right? You said that I don't know how many times during this trial. You still agree with it, right? Or did that change?
No, I said that he never made any verbal statement that he was surrendering. The only thing he did was he was turning his head and appeared to be going to the ground as though he were going to surrender.
So I actually have you down where you said that Mr. Boyd never surrendered.
No, he never surrendered.
Okay, so that's a correct statement right there. Boyd never surrendered.
As I stand by the statement I just made.
Okay. Now, a CIT officer, I think you use that as to bolster your credibility as an expert, right? That you've been trained in CIT, right?
No, I don't think I use it to bolster my credibility. It's just a simple fact.
No. So it doesn't go to your ability to be an expert.
I think it indicates that, yes, I have training in crisis intervention training, sure.
So I'm sure you know that every single police officer in Albuquerque, New Mexico receives the same 40 hours of training that you've received, right? Of CIT?
No, I don't know that.
Objection misleading, and Mr. Bregman's testimony.
Do you know, sir, whether or not every single police officer in Albuquerque gets 40 hours of CIT training?
And misleading also about current times versus in 2014.
No, it's not. It's not misleading at all. But thank you. Do you know?
No.
Did you know in 2014 at that time they were getting CIT training, sir?
No.
Did you care? Do you care? Does it come into any of your opinions?
Whether or not these officers had CIT training?
Yes.
The policy, it comes into my opinions as part of what the department's policy is, that they would have a CIT identified officer. The reports all indicate that there were 2 CIT identified officers, that was Monette and Niprath. So if every single officer had the same training, had the same, I have no idea why the report would indicate that only these 2 officers were CIT officers.
Mr. Keith Sandy had nothing to do with pulling the CIT officer off the incident, did he?
Not to my knowledge.
Mr. Sandy had no part in making the decision by Mr. Weimerskirts in closing ground, right?
Well, I think he had some part because he was part of this plan.
No.
It led to that.
Didn't you already say, sir, that Mr. Sandy did not know about that?
No, he didn't.
Okay. So there's a new theme that you have going, that you can actually be responsible for things you didn't know were going to happen.
What do you mean by new theme?
Well, things like, let me ask you a question. You have no understanding of canines, do you? You've never been really around canines, officers?
I've been around canine officers? Yes, I've been around canine officers.
Have you been around them when they deploy their dogs?
Yes.
They never follow the dog, do they?
Sometimes. It just depends on the circumstance.
Really, can you articulate right now a situation in which there was a subject in a real life situation in which you were there when a canine officer let a dog loose and followed right behind him?
I can't think of one, but I would not be surprised if that's happened. I mean, it's, over the years I've had so many, been in those positions so many times, I can't sit here and tell you an exact example.
Would you agree with me that it's a very rarity if it ever happens? It's a big rarity.
I don't know.
Okay? So, in Irvine, when you were, by the way, you've never been chief, right?
No.
Why was the prosecution calling you chief yesterday? Do you know why they were doing that?
I have no idea. I didn't ask her.
Okay.
Typically, even as deputy chiefs, that's the title that
I see.
you get called by.
Okay. But you're not a cop right now, right?
No.
Okay. How long has it been since you've been a cop?
About 4 years.
Okay. And were you chief? Were you an interim deputy chief?
Yes, at the city of Westminster.
Okay.
No, I was a deputy, yes. Interim deputy chief at Westminster and a deputy chief at Irvine.
Okay. So in Irvine, when an officer makes a mistake, and when he makes a mistake in a tactical situation, when they're trying to get a subject into custody, a suspect, a subject, whatever you call him, when they're trying to bring someone in and he makes a mistake, he just screws up and he gets too close to the bad guy. You understand so far my hypothetical?
Yes.
Do you teach your officers, hey, you're on your own, pal. You screwed up. You're all on your own. Is that what you teach in Irvine?
No.
It's not what we teach in Albuquerque either, is it? Or do you know?
I don't think any reasonable police officer would just abandon the officer.
No. So when a police officer's job is to provide lethal cover, and you understand that was Mr. Sandy's job, right?
Yes.
And then you understand that was his only job, right?
Yes.
When his job is to provide lethal cover and his officer that he's sworn to protect messes up and starts closing ground, he's got to follow with him, doesn't he?
Yes.
So Mr. Sandy's duty on that day, when Officer Weimerskirts made the faithful decision to close ground, his duty was to go right up next to him, wasn't it?
Yes.
And he did that, didn't he?
Yes.
And all along, while he's doing that, another officer's yelling, get on the ground, didn't he?
Yes.
And Boyd isn't getting on the ground, is he?
Nope.
Keith Sandy, and if you're Boyd, Keith Sandy comes right this far, doesn't he?
Yes.
And he perceives a deadly threat. You can't quarrel that, can you? You can't quarrel whether or not he perceived a deadly threat when he was right there in that moment, can you?
Objection, compound question, Your Honor.
Overruled.
Whether he perceived it or whether it was
he perceived. He.
No, I can't tell you what he perceived.
You don't know whether or not he perceived a deadly threat, do you? You don't know whether or not he perceived a deadly threat. It's a yes or no.
Asked and answered, Your Honor.
Sustained.
Okay. Just to be clear from my notepad, don't know what Keith Sandy perceived. That is what you just testified to, right?
Yes.
Do you consider perspective and perception the same thing in this context?
No.
What's different about them?
Perspective is the angle or the ability to observe. Perception is is the actual physical ability to observe and evaluate the information.
So the reasonableness of an officer's use of force must be evaluated from the perspective of the reasonable officer at... Do you see that?
Yes.
Okay, must be evaluated from the perspective. Perception, perspective. In this context, it's the same thing, isn't it?
No.
Okay. All right. So, tell me about your experience with a taser shotgun.
I don't have any experience with a taser shotgun. I'm familiar with them, but I've never used one.
So you agree with me that you're not testifying as an expert in taser shotgun by any means?
I'm familiar with the tool. I know how it works. I have a knowledge of it.
And same thing with a dog. You've never been a canine handler?
No.
Okay. You said something. Let's see if I get this right. You said it direct. I'm just going to go ahead and start a new sheet, I guess. You said, didn't you? Let me see if you still agree with this. If Boyd had taken a step or had lunged in any way, these officers would have been justified in shooting him.
I said that, yes.
I want to make sure I write that down correctly. So, if Boyd steps or lunges toward officers, then justified to shoot, right?
Yes.
And it's not even that, it's even more than that, isn't it? It's not just justified. It's their sworn duty to shoot.
I would agree with that.
So if they perceive, Keith Sandy from right here, perceived that day on March 16th, a step or a lunge with the two knives in the hand, and you agree with me, he had the two knives in the hand in the video that we just saw, right?
Yes.
If he perceived that, then it's not just justified. It's far beyond that, isn't it? It is his sworn duty that he has to shoot him, doesn't it?
As long as his perception was objectively reasonable, yes.
And that decision is in a split second, isn't it?
Well, ultimately, any decision to use force happens at the last second, but decisions don't always get made in a split second.
It's his duty to shoot if he saw this. If Boyd steps or lunges towards the officers, right?
Yes.
And now, we're in a courtroom, and you're coming in and saying that his perception wasn't reasonable? Or you don't know what his perception was, so you can't say it wasn't reasonable, can you?
That's why we have to look at these from the circumstances from a reasonable officer in the same position and determine whether or not it's objectively reasonable. If we simply rely on an officer who comes forward and said, this is what I perceive, therefore I use deadly force, then we would never be able to hold an officer accountable for anything.
You said some other things during the course of these 2 days about particular facts of this case. I want to delve into a little bit of that. You mentioned 308. What's a 308? Is that a rifle?
It's a rifle.
See? Why did you mention 308 in your earlier testimony on direct?
I can't recall.
Did you mention that there was a sniper somewhere?
I believe that Officer Perdue was a sniper and he was deployed, yes.
Okay. Let's be very clear about this. I want to hear this. So, do you know whether or not Officer Sniper had a view of Mr. Boyd when he was shot?
You mean Officer Perdue?
I'm sorry. What did I say?
Officer Sniper.
I don't know an Officer Sniper. Officer Perdue, do you know whether or not he had a view of Mr. Boyd when Mr. Boyd was shot?
I don't know.
Don't you think that would be kind of an important fact to understand before you come up here and give an expert opinion?
I think it's one of many facts, but I don't think there were many officers with firearms lethal capability pointed at Mr. Boyd.
Well, tell me exactly how many officers that you know of today, right now, based on your thorough investigation of this, tell me how many officers you know of that could have used lethal force on Mr. Boyd at the time that he was shot.
At the time he was shot, the only officers that could have used lethal force because the officers were moving would have been Officer Sandy or Officer Perez.
There was nobody else that could have stopped the threat, was there?
There were other officers in the area. Whether or not they could stop the threat, I don't recall those questions being specifically asked of them or their positioning.
So is that a no?
Well, I have to rely on the investigation, so it's a no.
So the only two people you would agree, based on some of the stuff that you read, the only two people that had the opportunity to actually stop the threat of Mr. Boyd, the only two people, both took that opportunity, Mr. Sandy and Mr. Perez, to stop that threat, didn't they?
Yes.
And by the way, in your investigation, did they ever talk to each other before this moment?
Before which moment?
When they shot Mr. Boyd.
No.
They did?
No.
So, let's go back. Do you have a problem with Officer Perez's perception? What he perceived?
Well, the same issues apply. I don't know exactly what he perceived. I only know what he said.
So, to be clear then, you don't know what Officer Perez perceived, right?
That's right.
So when he, and I know you still say that you didn't see a step, but if Officer Perez or Officer Sandy said that they saw him take a step, you have no way to refute that, do you?
Do I have a way of refuting that? No. I have to rely on the statements that they made. And
Right.
the first time I heard anybody talk about a step is during your opening statements.
Thank you. You answered my question.
He should be allowed to answer the question.
He can be redirected.
I agree, you can do redirect.
Oh,
So let's just be clear about what you have reviewed. I'm going to go through a little bit of a checklist, and you tell me whether or not you've done that. And I don't want you to look at anything. I just want you, if you need to look at something, then you tell me, okay? Do you believe that you've looked at all the videos in this case from start to finish?
No.
Do you believe that you've read in their entirety every transcript of every interview done in Detective Stone's investigation?
If it was part of his investigation, yes.
You said earlier that you read the summaries. Did you read the actual transcribed interviews?
If they were attached and part of the lengthy investigation, yes. I don't recall whether they were part of it. I just don't recall. I know that the two primary officers' transcribes of interviews were attached. I just don't recall about the others.
Okay. Who did you talk to and ask to make sure that you had a complete report?
Throughout this case, I was speaking with Ms. McGinn.
Right, but did you ever go, hey, I want to make sure I have everything? Did you ever say that to her?
I don't recall. I don't recall having that conversation.
Okay. You've already testified, I think, that you've not spoken to any witness, correct?
Correct.
Okay. And you've never been to the scene of this incident, correct?
Correct.
Okay. You say there's this plan. I just want to make sure. You can't point me to a specific place in any of the transcripts that you reviewed or anything else where Keith says, this is the plan we're going to do.
That's true.
The only reason you say he was part of a plan was because he was there, right?
Yes.
You can't testify to a single thing he said during those conversations, if he said anything at all, can you?
No, I guess I can't recognize his voice.
So you made a big point out of saying, look how flippant or sarcastic the officers were when they said, you talking to me or him, right? You made a point out of that to tell the jury in the court today, that, right?
I certainly made a point. I don't know if I made a big point, but I think I made a point, yes.
Who were the two officers involved in that?
I'm not sure.
Do you know that one of them was a state police officer?
No.
Do you know whether or not the state police were actually called out because Boyd wanted to talk to a state police officer?
I know that, yes.
Okay. So do you know whether or not that was Officer Weimerskirch that said that, or the state police officer, or do you even know?
I don't know.
You certainly don't hold their statements against these two officers, do you?
Not if those officers didn't make it.
But you don't even know, do you?
Well, I was asked a question about whether or not the officers were taking all these threats seriously, and I pointed out there was one time where I felt that no, they weren't taking it seriously.
But you don't know the context of that, do you? Because the state police officer had just come up to negotiate with Mr. Boyd. You don't know whether or not Officer Weimerskirch, for example, was saying to Mr. Boyd, are you talking to him or are you talking to me? You don't know what the context was, do you?
I only know from what I heard on the tape.
Right, you don't know what the context was, right?
No.
And in fact, the only time you ever heard it was in this courtroom, right?
No, I think I heard that one before.
Have you? Okay. Now, if you had listened to, did you ever listen to all of the dispatch between all the various police officers?
No.
So you wouldn't know that the sniper, Officer Perdue, had said prior to these gentlemen going up the hill to confront Mr. Boyd that 22 is down. You don't know what that means, do you?
No.
You don't?
No.
I thought you were involved in SWAT.
Yes.
And when you have an officer with a long gun who perhaps may be called a sniper or not, what do they say when they aren't seeing the suspect anymore?
Well, it depends. We use different radio codes across the country, so the fact that they use a particular code here is not something I would know.
Do you have any reason to doubt the fact that the person up on the hill said, I'm down, Mr. Perdue, Officer Perdue?
I don't have any reason to believe it or disbelieve it.
So, how did Keith Sandy, let me understand that, let me just get an understanding of how well you know this case. How did Keith Sandy happen to be on this call, do you know?
He received a phone call from a dispatcher.
Okay, it wasn't him listening to radio dispatch, was it?
No, not to my understanding.
And you heard Ms. McGinn in opening say that he heard it, he was listening to the radio, so he wanted to run down and be a part of it. You heard her say that, didn't you?
Yes.
And that's not true, is it?
No, not to my knowledge.
Have just a moment, Your Honor. So, let me take some notes here. When Keith Sandy had a perception of immediate deadly threat by Mr. Boyd upon Officer Weimerskirts, he had a duty then to shoot him, didn't he?
As long as his perception was objectively reasonable, yes.
You said that, I think earlier, that based on what you've seen of the training, it was all lawful training, right?
I didn't see anything that caused me concern.
And you didn't see anything that, for example, Officer Perez didn't follow his training. He followed his training, didn't he?
Well, I think part of the training is not to use deadly force unless it's objectively reasonable. So there was, other than that, no.
And the same thing with Keith Sandy, isn't that correct?
No, with Keith Sandy, I believe that Sandy, because he was part of this group that made this reckless plan, I think that impacts him.
Again, part of this group, the group that you can't even say what he said during it, right?
He's part of that group, yes.
So that's just because he's associated with them at the time, he's obviously wrong.
It's not because he's associated with them at the time. He's there. He's a 19-year police veteran who could have or should have spoken up to say who engaged in this plan that was reckless.
And you said that not one of those lethal uses was wrong, right? Less lethal uses was wrong. Not one of them. The flashbang was okay by itself, wasn't it?
Yes, by itself, yes.
The dog by itself was okay, right?
Yes.
The taser shotgun was okay, right?
Yes.
But you find fault with the fact that they were all used the way they were used.
I find fault with the fact that that plan was implemented in the way it was done, yes.
And the biggest fault you find is with Officer Weimerskirts closing ground, right?
Well, I think you have to look at it in a totality, so I don't think that you can point out one biggest. I mean, certainly that had an impact, but every step of that plan had an impact and led to Officer Weimerskirts' actions.
You know, one last thing. You talked about the Tueler drill, right?
Yes.
The Tueler drill is 21 feet, right? Am I right?
Well, for circumstances, but yes.
Well, 21 feet, 1.5 seconds it takes for the average person to cover ground with a knife and stab you, right?
Yes.
1.5 seconds, that's it. That's like that, right? It's pretty quick, isn't it?
It's 1.5 seconds.
Yeah, and by the way, from the time where I was showing you this, where you said you didn't see any step, you know what the video I was showing you?
Yes.
Do you know from the time that he did this to the time that Keith Sandy actually shot was less than a second? Do you know that?
Objection, Your Honor, counsel is testifying.
Oh, I'm asking a question.
This question is permitted.
Is what?
It's permitted.
Did you know that from the time he took a step, or what I was showing you, I believe to be a step on the video, from that time until he pulled the trigger was less than a second? Did you know that?
For Perez or for Sandy?
Sandy.
I knew it was close to that, yes.
And you have no idea about reactionary gap time, right? You're not an expert in that, are you?
I'm not an expert in it, no.
Okay. You understand the concept, though, right?
Yes.
And the concept basically is, if I take an action, it takes you a little bit of time to see the action and respond, right?
Yes.
Okay? To react, right?
Yes.
Okay. So, how long does it take for someone from right here? If 21 feet, it's a second and a half. What's your guess? From 9 feet, it's going to be less than half that, right? Makes sense, right?
I don't want to guess. I've never participated in tests, and I haven't seen any scientific tests that would tell me, but I think that that would be an estimate, yes.
About at least half, right? Cut it down by at least half, would you agree with that? 0.75 seconds? 3/4 of a second.
Again, it depends on terrain, it depends on obstacles, it depends on a lot of factors.
How about does it depend on if someone's close to 4 feet higher than you on top of a hill?
Every factor. The terrain is certainly a factor.
So if you're higher up, you'd agree with me, I think this makes sense. You don't have to be scientists to do this. If you're higher up, you can go down the hill a lot faster than if it's on flatland, right?
As a basic proposition, if you're elevated, you can move downhill faster than you can go uphill.
So yes is the answer, right?
Yes.
So would you agree with me that within less than 3/4 of a second, Mr. Boyd could have stabbed Officer Weimerskirtz?
Well, again, I think
from the 9 feet away.
you're ignoring the other parts of the terrain, which is the rocks and debris and things, and the fact that there was a dog in between them.
Yeah, you've mentioned that. Let's talk about that. You think the dog would have prevented Mr. Boyd from stabbing him?
I think it's an obstacle, and I think that is that one factor. Could the dog have engaged? Yes.
If you're walking your dog, I can still walk up to you and stab you, sir. The dog doesn't stop you from doing that, does it?
It's not a matter of me walking a dog. It's a police dog that's been released.
Police dog doing circles, as we saw, in front of the officer, right? Right?
Like I said, and I testified that the dog did not engage the first time.
Right. The dog wasn't particularly interested in Mr. Boyd, was it?
He did not engage.
Right. So therefore, the dog wasn't going to be an obstacle, unless you're just guessing or speculating at that, right?
No, his physical presence is just like a rock. His presence is an obstacle.
But it's not a definite obstacle, right? I mean, Mr. Boyd, you would agree with me, could have stabbed Officer Weimerskirtz in 3/4 of a second from where that man was, right?
No, I don't. I can't. I'm not a scientist. I can't tell you that.
You don't know.
I don't know.
But yet you can give an opinion that their shooting him wasn't reasonable.
Yes.
And I'm done with this witness. Thank you.
Well, Mr. Noble, it's been quite an afternoon. Let me start with the question that Mr. Bregman wouldn't let you answer. And that is, he said, talking about this step, and that the officer perceived a step, and you said, the first time I've ever heard anybody say that was an opening statement. I think that's what you were about to say when he cut you off. Can you explain that to the jury, please?
Yes, ma'am. That's the first time I ever heard anybody say that there was some kind of step. In opening statements, it was described as a lunge. I recall the attorney making a large step, stomping toward the jury box. Never heard that before.
Okay, and you say you reviewed a lengthy investigation report. Did you review all 899 pages of the investigation report that Detective Stone produced?
Yes.
And in that investigative report, were there statements from both these officers in that investigative report?
Yes.
Including both statements and summaries of statements of other officers who were at the scene, is that right?
Yes.
Okay. And in that report, in those statements, did you review the statements to see what both of these officers said at the time, back at the time of the shooting, about what they perceived?
Yes.
And were those statements given the night of the shooting?
No, they were given a couple days later.
All right. And why is that important as far as the officers being able to get their thoughts together?
Objection outside the scope of cross-examination.
Concur.
Outside the scope of direct.
Judge, it is not. They asked specifically about this new thing.
Speaking of objection, John, I don't agree with this.
All right.
You can approach.
Okay. did you review the statements to determine what these officers said at the time about what they perceived?
Yes.
Did either officer ever say that they ever saw Mr. Boyd lunge at them?
No.
Okay. In fact, what did Defendant Sandy say that he saw right before he shot?
He said that Mr. Boyd was turning to his left.
Okay. And then before he shot the third time, what did he say he was doing?
I believe he said he was going toward the ground, moving toward the ground.
Okay.
Yeah, either he knows that, or I'm going to ask him to be stricken. I believe he says, we can't have speculation based on what somebody actually said. So I've objected and asked the last part of that be stricken.
Let me get some clarification.
Yes. Did he say that he was still standing and so he shot a third time?
No.
Okay. No one ever said, in Defendant Perez's statement, you never saw Defendant Perez say that he shot because you saw him take a step.
No.
All right. Mr. Bregman did a demonstration with you with the knives and the 9 feet. What he didn't put in between you was the police dog that was there, and you talked about this being an obstacle. Can you explain to the jury if someone is standing with, and you, I guess you'd be the person with knives and I would be the police officer in this particular scenario, what does just having a police dog, whether or not the dog bites, having the police dog there do as far as the person being able to get to you?
Well, you know, anytime you have any type of obstacle, it's going to slow it down. It's going to slow events down. Whether it's an obstacle in terrain, like a rock or a bush or a police dog or a chair, it's going to slow things down. It's going to take a little bit longer.
And again, if I have a gun pointing at you over this police dog, who's going to be faster, you or my bullet?
It'll always be the gun.
Okay. Is it ever, under any policy, appropriate to shoot a person to protect this police dog?
No.
And why is that?
You know, as much as we are all dog lovers.
No, seems facts not evidence. There's no assumption that anybody's shot someone because of a police dog.
We don't allow that question.
Yeah.
We use police dogs to send them into situations where we recognize the dog may become injured in order to prevent an injury to a police officer or somebody else.
Okay. I'm just going to hop around and touch on a number of things that they talked to you about. I think you were asked by Mr. Robles that the police officers spoke in a polite, professional manner. Were the police officers aware that they were on tape?
Yes.
Was Mr. Boyd aware that the police officers were tape recording
That calls
this?
for speculation.
Sustained.
Was there-
Last answer be stricken.
Was there, well, not on
Because he said yes to the, that's what I was objecting to the previous one.
Your objection is to the one about the officers
Yes.
knowing they were being
Yes,
recorded?
yes. Which officers? Who? What? Disagree with me. And that's guessing.
Let me rephrase my question, Judge.
Didn't talk to him.
I'll make it very clear,
You may
Judge.
rephrase.
Were the officers who were recording on their tapes aware that they themselves were on tape?
Yes, if an officer's turning on his tape recorder, he's going to be aware that he's going to be recorded.
All right. Did anybody ever tell Mr. Boyd that they were tape recording him?
Not to my knowledge.
And the one time that Defendant Sandy didn't think he was on tape when he was down at the staging area
Judge,
talking
she's
to...
testifying, Your Honor. She's testifying. The one time Keith Sandy didn't know he was on tape, that's testimony, Your Honor.
All right.
Objection.
Sustained.
Are you aware of a statement that Keith Sandy gave where he was not speaking in such a professional way and made kind of a crude statement?
Yes.
All right.
Objection, this is beyond the scope of both.
Sustained.
and prosecution.
Are knives equally deadly for a gun?
It depends on the circumstances, but guns, you know, certainly you can be a greater distance away and you don't have to close that distance in order to attack somebody.
All right. And in your particular case where you had to shoot somebody, was it a knife or a gun that was involved?
It was a gun.
Mr. Robles asked you a series of questions about CIT Officer Monette and asked if he surrendered to CIT Officer Monette, and was your answer that he never surrendered to CIT Officer Monette? Is that right?
Right.
When a CIT officer is negotiating with somebody, how much time is there given to be able to try to resolve the situation?
You take as much time as you need, depending on the circumstances, and obviously at some point, you know, some type of intervention is going to have to happen, but that's many hours down the road.
Okay. They quoted something from your book about saying often police respond in the middle of the night with little time to put a plan in place. Does that quote apply to this situation?
No.
Why is that?
Well, it doesn't apply to the officers who developed this plan because they had been there for over an hour. This situation had evolved over 3 hours. There was a lot of time. There was time to communicate. There were supervisors there. There were people to run, to ask questions of, to get input from. This was not a split-second type situation for them where like somebody's jumping out at them and they're suddenly making a decision.
Okay. Was there time or was this plan made in a split second, this plan that Sandy, Ingram, and Limberskirch made?
No, it was made over a period of time.
Did they have time to de-escalate or to stop when the plan failed?
Of course.
And did they have to call backup or did they already have backup on the way when all of this was happening?
Well, yeah, they had already called, for example, the beanbag shotgun. They had asked for that. Ornelius went back to the SWAT command vehicle, to the vehicles to obtain it and was headed back up the hill.
Okay. They asked you a question about what was in Mr. Boyd's mind and how do you tell his intent. After he was told to get on the ground, he made a statement right before he turned, and the statement, I think, was, don't make fun of people.
To the lawyer testifying, Your Honor.
What was the
Certainly leading the testimony.
What was the statement that Mr. Boyd made right before he turned?
That you shouldn't make fun of people.
And how do you interpret that statement as far as being aggressive or passive?
Objection relevance, how he interprets it.
How would a reasonable police officer, objectively reasonable police officer, interpret that statement?
They would interpret that the officers were being, that the subject saying it is being passive, reacting to something the officers had done.
Okay. They went back and forth on this hindsight thing, hindsight, foresight. Can you judge anything in foresight? Or review anything in the future in foresight? Can you?
Judge, object to the extent it calls for a legal conclusion. I don't know. I think he sustained all the objections prior to that line of questioning.
Overruled.
Okay. Can you explain what you were trying to say to them when they said, oh, you can't look at anything in hindsight? Is that true?
No, you have to look at things. You can't look, we don't know what's going to happen in the future, so we can't assess things before they happen. So the only way for us to assess them is after they happen.
Okay. And is it true that what you have to do, the way they read this SOP, is that if a reasonable officer says, hey, my perception was I was in danger, that you interpret it by that officer's statement and you don't look any farther than that?
Testifying and leading, Your Honor, Judge.
I'm directing to where the question was that they were talking about, Judge.
Well, refer to the question.
Okay. They asked you a question about, doesn't this SOP say that you have to interpret it based on the reasonable officer's perception at the scene, and if he says, I thought it was a threat, that's the end of the inquiry. Is that what the SOP says, and is that how any police department interprets that SOP?
Objection to the extent that that calls for a legal conclusion, Your Honor, and it calls for speculation.
Testify about the SOP.
And it's the issue of the Albuquerque Police Department. It's not any other police department, it's the Albuquerque Police Department. And that's not the question that was asked.
Okay. Could you answer that as far as the Albuquerque Police Department is concerned?
Yes.
Okay. Explain to the jury what that means.
Yes, if it's interpreted that way, that it's the perception of the officer who used the force, again, you'd never be able to hold any officer accountable for anything because every officer would say, I believe the force to be appropriate, therefore you could never question him, even if it was the most outrageous use of force.
Okay, and so what do you have to look at to decide if it is reasonable?
You have to look at the totality of the circumstances. You take an objectively reasonable officer, put in the position of the officer who used the force, and looking at the same information that that officer knew. So you don't give him any new information, the same information, the same set of circumstances, and you evaluate it from that perspective.
Okay. You have given the opinion that these officers should not have fired because James Boyd posed no immediate threat of death or great bodily harm.
Objection leading.
I'm going to ask you if that is still your opinion.
Overruled. You may answer.
Yes.
And did Mr. Boyd ever do anything that would justify deadly force in this particular situation?
No.
And according to their own reactive control model, Did Mr. Boyd ever cross this line that you drew here so that the officers could use deadly force?
No.
Did he ever attack these officers?
No.
Did he ever lunge at these officers?
No.
Did he ever even step toward the officers?
No.
And did these officers ever say in their statements that that had occurred?
No.
You know, this is a criminal case, which has a different standard of beyond a reasonable doubt. So I want to ask you, when you give the jury your opinion about the inappropriate use of force here, how sure you are about your opinions in those areas.
Ultimate issue, Your Honor, I'm just going to object. This has been asked and answered, so how sure are you?
I'm going to sustain that objection.
Even after cross-examination, can you look the jury in the eye and say that the use of force in this case was inappropriate?
Your Honor, objection asked and answered.
Sustained.
What is your opinion about whether both officers should not have crossed this line themselves and used deadly force in this case?
Objection asked and answered, Your Honor.
No, Judge, that was not. It was about whether Mr. Boyd crossed the line.
I think it's the same question. I'm going to sustain
Okay.
it.
What is your opinion about whether the officers violated the reactive control model themselves?
Objection asked and answered on direct, Your Honor.
It has been asked and answered.
On directed, but I think they brought this up again and brought up the
I
reactive
think
control
he
model.
answered it when you asked him if Mr. Boyd crossed the line.
Okay, and I'm asking a different question now. I'm asking whether the officers violated this procedure.
Same objection, Your Honor.
I'm sustaining the objection.
All right, Judge. Do you have, they've done hours of cross-examination. Has anything that they've said shaken your opinions on cross-examination, or do you still have the same opinions you gave these jurors on direct?
I still have the same opinions.
Okay. Thank you, Your Honor. No further questions?
Thank you. You're free to go.
Thank you, ma'am.
Your Honor, can we approach before the next witness is called?
Sure.
And may Mr. Noel be permanently excused, Your Honor.
Yes.
Any opposition to that? Mr. You may be seated.
Your Honor, keep up this good.